Honorable colleagues, we have a quorum, and I hereby call the meeting to order. Et je vous souhaite la bienvenue au Comité des Affaires sociales, des sciences et de la technologie. I'm Kelvin Ogilvie, a senator from Nova Scotia. I'm going to chair of the committee. Mario Bellissimo, a lawyer who is appearing here as an individual and is from the Bellissimo Law Group. Please.
Good afternoon, Mr. Chair, Senators, and my fellow panelists. Thank you for inviting me. It is both an honor and a privilege to be before you today to discuss what is a very important piece of legislation. I understand my speaking notes are before you as well as the submission from the Canadian Bar Association. I come to you today wearing three interrelated hats: as a Canadian citizen, as an immigration lawyer, and as treasurer of the National Immigration Law Section for the Canadian Bar Association. I want to preface my comments by stating that there have been many creative initiatives and excellent efforts on behalf of the Honourable Jason Kenney, Minister of Citizenship, Immigration and Multiculturalism, as well as his staff. And as I've commented in other mediums, the changes have been fast and furious. And it's difficult when you're trying to weave changes into what I consider to be a very delicate tapestry, which is our Canadian immigration system. Some of the changes have been positive and others have not. Unfortunately, Bill C-38 is, in my opinion, a serious step in the wrong direction. I'll focus my comments today on both the scope and implications of this legislation. It's regrettable that we are dealing with this in the context of an omnibus bill. With the significant impact and sweeping nature of the changes, quick time frame for its passage, militate against meaningful comment or debate, but I will do my best to communicate what will inevitably come out as a very impassioned view. As the committee has heard, federal skilled worker applications are being returned, along with an estimated $130 million in processing fee, without interest on those fees, without timely notice of the change in policy, without legal right of remedy or indemnity, or any consideration of the merits of those applications. It also introduces unprecedented ministerial instruction over permanent and temporary resident processing. It would give the minister power not only to establish conditions by category, which is not all that new, but also can change the conditions once the applications have been filed. We recognize the importance of ensuring Canada's immigration system responds to our changing labour needs. However, Bill C-38 far overreaches its stated objective, much as my colleague Ms. Douglas has commented. I highlight in the CBA submission and echo those that Part 4, Division 54 should be withdrawn or at least separated and referred to the Standing Committee on Citizenship and Immigration for proper study and debate. Before looking at the implications, I want to speak to some of the underlying assumptions for the need for this legislation. By all accounts, or by many accounts, in November 2008, there were approximately 800,000 persons in the backlog. Currently, we're at about 280,000, or about 65% less 3.5 years later. I read with great interest the comments of Sandra Harder, Director General, Strategic Planning and Policy and Planning for Citizenship and Immigration Canada, in response to questions from Senator Colbeck, Martin, and Gordy when she testified before this committee on May 31st. 4 points I wish to highlight. One, she confirmed that the oldest file in the backlog is from 2003, so some applicants have been waiting for 9 years. She also stated efforts have been made to communicate with applicants in the backlog to close their existing application and reapply, but only 6% took up the offer. 3, she commented that the backlog would take until 2017 or 18 to clear. And finally, that to accommodate the admissions, we would have to raise our immigration levels from 240,000 to 265 to about 500,000 to 600,000 immigrants for a 2-year period. With the greatest of respect, these comments are difficult to reconcile. One, so far as applicants were contacted, they were not offered a refund or to close their application, but to reapply anew. And with Minister Instructions 1, which came out on November 28, 2008, only 38 occupations were eligible. So it stands to reason that many, or I understand before the committee, she testified that they do have those numbers of who would still qualify under those occupations, but it was unclear. Yes.
your independent content. You
Yes.
are now at 5 minutes.
Okay.
And I will close you off in 2 more minutes.
Okay. Well, let me get then very quickly to the independent content, which is why these drastic measures now, as the backlog has been significantly reduced. Based on the pace the backlog has been clearing, why would another 5 or 6 years be required? Assuming a certain percentage of applicants would be approved, it's unclear why we'd have to raise levels to 500,000 to 600,000. There's also comments made by Minister Kenny with respect to ensuring that our government is sending a clear message that our doors are open to those who play by the rules. With respect, the door would be shut, and we couldn't stand by that statement again. He's also indicated that the system must be fair, well managed, that it does not tolerate queue jumping. It's difficult to understand how that statement will be reconciled to someone who's been sitting in the backlog since 2005, sees an applicant with the same occupation approved with visa in hand in 2000 and 2010. I know I'm short on time, so I get to the issue of what special efforts have been given to process these applications. Have they been given priority? Has any of the interest that's been accumulated over all these years been put towards processing this backlog? We are looking at litigation in the federal court, which is already overtaxed, and what is the cost benefit? Further, with respect to a minister's ability to manage and be responsive, that is a fair proposition. However, we're moving from flexibility to inability to manage a transparent or predictable and inviting immigration program. What's the problem with changing the rules mid-course? It might seem flexible, but for those, and the government has spent a lot of time on cracking down on scrupulous representatives, this would allow the immigration program to become a moving target, and one that would be difficult to operate. So I conclude by echoing the CBA's submissions, and there are 3 of those that are before you. And I conclude by stating that the deleterious effects of this legislation far outweighs its benefits, and mere administrative expediency should not trump core values and tarnish the real value and integrity of our immigration system. There is a lot at stake here, and I urge the senators here to take this very seriously. If this legislation passes in its current form, we will look back on it with regret.